Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by wealthmanagement.com senior editor David Lenok.
Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management. Hello, everyone, and welcome to the latest episode of wealthmanagement.com's Celebrity Estates, Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that can just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trusts-estates. Our monthly journal features tax law updates, wealth planning, retirement planning, and much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. We're joined today by Tasha Dickinson. Tasha is a partner in Pitney's West Palm Beach office. She's a Florida Bar board certified wills, trust, and estates lawyer, and exclusively represents individuals and families in sophisticated estate planning and estate and trust administration. She has extensive experience with complex wealth preservation strategies, business succession planning, and charitable planning. She represents fiduciaries in complicated estate and trust administration matters, has developed a niche working with family offices, and has written and lectured extensively on residency planning. Thanks so much for joining us, Tasha.
Thanks for having me, David.
So, the subject of today's episode is the Prince of Darkness himself, Ozzy Osbourne. Ozzy was an English singer, songwriter, and media personality. He co-founded the pioneering heavy metal band Black Sabbath in 1968 and rose to prominence in the 70s as their lead singer. He performed on the band's first 8 studio albums before he was fired in 1979 due to his problems with alcohol and other drugs, somewhat of a ludicrous understatement to simply call them problems. Ozzy's career as a solo was even more lucrative. He ultimately released 13 studio albums, 7 of which went multi-platinum, and it resulted in over $100 million in album sales. After spending a good portion of the 90s out of the spotlight, Ozzy kicked off the third act of his career as a reality TV star with the Osbournes in 2002. The man who once famously bit the head off a live bat during a show and terrified religious people the world over was now famous as the tottering, unintelligibly mumbling patriarch of a surprisingly normal family, America's evil dad, if you will. Ozzy died at home from a heart attack in July of this year at age 76, 13 days after his farewell show. Unbelievable longevity for someone who took such famously poor care of himself in his youth, rivaled only maybe by fellow famous, inexplicably long-lived drug user Keith Richards. Ozzy left behind a roughly $250 million fortune, plus the rights to future royalties on his massive catalog and his still valuable likeness, to be distributed among his current wife Sharon, herself a notable television personality these days, and 6 children, 3 from his current marriage and 3 from his previous marriage to first wife Thelma Riley. Tasha, we've spoken on this show about blended families quite a number of times before and how quickly cracks in what initially appear to be a solid structure can start to show once the person linking the disparate aspects together passes on. The Osbourne family looks like a pretty textbook example of such a family, with the very real possibility of potentially some sort of dispute. What are some of the techniques that savvy planners can employ to diffuse these tensions both before and after death? And what sort of complications do the presence of artistic royalties present to planners in this regard?
Yeah, those are all really good questions, David. First, I want to say that a couple of things. Number one, I do not represent Ozzy Osbourne nor any member of his family. I am also an estate planner. I'm not a litigator. So my knowledge is limited to estate planning, although unfortunately I do get involved in litigations when things go south in the estate planning context. And the other thing I'll say before I directly answer your question is I don't think that at this juncture we know that there's going to be any fighting that goes on in the Ozzy Osbourne estate. I certainly hope that that's not the case, but the possibility certainly exists for the reasons that you have already alluded to. When there's a blended family, the patriarch, in this case, Ozzy Osbourne, is kind of the glue that binds the family together. And with his absence, there's a propensity for any fissures in the relationships between family members to be exposed and widened. But I'm glad you do this podcast because people have naturally a lot of interest in celebrities. But the truth is that celebrities are no different than any other ordinary family. And so I think it's great that you're able to tap into the interest that people have in celebrity cases to really highlight the issues that exist on an everyday basis from other families.
Mm-hmm.
And blended families in particular give rise to a lot of different issues. The first part of your question is, what are the techniques that we can employ to mitigate these types of issues? And I think that's kind of a three-part answer.
Mm-hmm.
And the answer is, number one, we want to be cognizant of the natural conflicts that exist between spouses and children from a prior marriage, for example. And so doing the work while someone's alive to minimize the number of touch points, if you will, that there will be between the surviving spouse and the children from the prior marriage is very helpful.
Mm-hmm.
And so we could do that by giving certain assets to a surviving spouse and giving other assets to children, or using different types of assets. There's a lot of different strategies we can employ, and we can talk about that a little bit more later. But the key is to make sure that the surviving spouse and the children from a prior marriage aren't in a marriage, so to speak, after the death of, in this case, the patriarch. Mm-hmm. The second part is thinking in earnest about who's going to be in charge of administering the estate at the death of the patriarch in this case. And so often people think that it's a good idea to have a surviving spouse in charge or children in charge. But the truth is, when there's a blended family, the most successful answer is none of the above. The most successful answer is to have someone who's independent and objective, who is administering the estate to minimize the potential for conflict.
Yeah, absolutely. I'm glad you brought that up, Tasha. I think when we talk about blended families and the sort of the conflicts that can happen between the different parts of it, it's real easy to sort of, in your mind's eye, just picture like the evil stepmother and the kids who hate her, and it's sort of this pre-existing animosity. But often that's not necessarily the case, right? That the family can largely get along, and there is just, sort of an undeniable natural instinct to favor your own children when you're making choices between them and other children that perhaps you love, but are not your biological descendants necessarily. So I want to just, get across here that it's not, we're talking about blended families and the conflicts that can happen. It's not always as obvious as, well, they obviously hate their stepmother, or they like their step siblings, or there was some sort of acrimonious divorce where everyone hates each other. Often these are totally solid families who get along. And it's the death of the patriarch in this case that causes some, potentially minor cracks to show that can result in fairly large, issues when it comes to divvying up things amongst, your children or your biological children and your stepchildren.
Right. And I can use an example of a common planning strategy to further illustrate that, David. So a lot of people will say, well, I want to put my assets into trust for the benefit of my spouse during my surviving spouse's lifetime. And then I want to give the assets at my surviving spouse's death to all of my children. Okay, so in the Ozzy Osbourne case, this would mean the assets would be for the benefit of Sharon. At Sharon's death, the assets would go to the 6 kids. Mm-hmm. So there's a conflict inherent in that because Sharon in this example, and again, this is not intended to be indicative of what Ozzy's estate plan was because I have no idea what his estate plan was. But in that case, the children are watching over what Sharon is doing during her life, because they get the remaining assets at death. And so even if it's not a conflict already, there's a high likelihood there'll be a conflict at some point in the future because inevitably a child will think that the surviving spouse is spending too much money.
Mm-hmm. Yeah, but you kind of create a conflict, or one doesn't exist in a lot of ways, right?
Right. So you've created this conflict unknowingly. Nobody mm-hmm. would choose to create a conflict between the surviving spouse and the kids. But if you just employ the most common estate planning strategies and don't think beyond that, you've created this conflict unwittingly that could literally destroy your family. And I think that most people, when they, come in for estate planning, they would tell you that their primary objective is to make sure that the surviving spouse and the children live in harmony post-death.
Yeah, absolutely. It's you want to provide for everyone and being fair. And I'm doing so much air quotes. It's really excellent radio that you can see me doing these air quotes. That and what exactly that means for any given family and the ramifications that just the equal division can cause, even if that initially on paper is fair by the black letter definition of it, right?
Right. And remember, the potential for conflict is between the kids and the surviving spouse, but also the kids between themselves.
Yep. Because, obviously they're the children, some of them are the children of that spouse, right? They may be more protective of their biological parent than the other children would be. And then,
correct.
So there's a lot of emotion that can go into there, even if, these people are part of the same family.
Exactly. And David, just so I don't forget it, I said there were 3 things. I just want to say the third one, and then we'll go back to any of those that you want to explore further. The third one is communication mm-hmm. and setting expectations, because litigation happens typically when people's expectations are not met. So the ability of the decedent to be able to communicate with family members, the surviving spouse or the kids, to set expectations a lot of times can prevent litigation. But then when the decedent dies, obviously that opportunity is lost. So mm-hmm. taking advantage of that during lifetime can really decrease the potential for litigation post-death.
Yeah, absolutely. I always basically every episode joke that we should just call this the communication podcast because it's kind of always the answer to every question that we ask on this show is like, just talk to your kids while you're alive. Obviously significantly easier said than done. Otherwise everyone would just do it. But it does keep coming up, and it is always, the easiest way is to manage expectations face to face rather than, document to hand, so to speak.
Yeah. And I think it's for people to realize that it's not, communication doesn't mean that you divulge all of mm-hmm. every detail of what your estate plan looks like or what your assets look like. I think there's a lot of space between full disclosure and saying absolutely nothing that can really help family relationships at someone's death. And so I encourage families and advisors to talk to families about trying to hit kind of a happy medium, if you will, where you can at least set some expectations without compromising, kind of I don't want to call it the secrecy that you want to, but maintaining the privacy that you seek to have.
Yeah, and also there's the sort of the buy-in aspect as well can be very helpful, where, just getting people's expectations and fears and such and reasonings for doing certain things out on the table is just good therapeutically. But also if people feel heard, in this case, the heirs feel heard, like they've had some sort of input into the plan, even if ultimately no changes are made based on their input, they at least have some level of buy-in because they feel like they had some part in making this plan, even if it's not exactly what they prefer. The fact that they participated at all gives them that little extra sense of ownership over it, where they may be less likely to, start picking it apart after the fact.
That's right. And I think having conversations within the family sometimes gives the matriarch or the patriarch perspective that they didn't have before. So it's actually very helpful in establishing the plan. And you're right. Sometimes mom or dad, they hear what their kids are saying and what their concerns are, and maybe they decide not to act on it, but at least the children have had the opportunity to discuss what their concerns are. And in a certain way, they feel as though they're part of the solution. Mm-hmm. And again, to your point, that makes them more comfortable and more vested in the estate planning process.
Yeah, absolutely. So, we're talking about conversation and sort of very intra-family things right now. But one of, the very first answer that you gave to the questions involved someone who, was not part of the family at all, right? The idea of, bringing in sort of an independent, trustee or executor. I mean, I think it's pretty, just because that is a big job that can often get sort of thrown in the lap. I think less so a trustee than an executorship, but still both. That gets kind of tossed in the lap of like the most trusted family member, the most trustworthy family member. Whereas, this is often a full-time job, managing depending on the size of the estate. And, people may or may not be equipped to handle it well. And that's not even considering, the fact that, other members of the family may view them as biased and having, counter, interests against their own, so to speak.
Right. Well, I think it is a big job, and in any case, blended family or not. And so I think the idea of having someone independent to help or to do that job in any case makes sense. And I think when people are doing estate planning, they think it's an honor for their children. Mm-hmm. Or their surviving spouse to have that job. But it's not an easy job, and it's not all that attractive, if I'm being honest about it. So an independent trustee or fiduciary makes sense in any case. In the situation where there's a blended family, the reason why I think an independent fiduciary makes sense is because that person acts without emotion. And by definition, a blended family has certain emotional baggage attached to it that can get in the way, increase tensions, and therefore increase the likelihood of some sort of litigation. Whereas an independent trustee doesn't have that. And so I think even more so than in a kind of more traditional family, in the case of a blended family, it really makes sense.
Mm-hmm. And I think, it's important to stress that we've basically spoken about one very emotional thing and one sort of unemotional detached thing, and need a happy medium with both. Obviously, if you have an independent trustee is a great tool, but if you haven't addressed any of the emotional issues that may be below the surface, then bringing in a completely unemotional surrogate is not necessarily going to have the effect you want, because all those emotions are still going to roil. In the same way that just because you address the emotions in a conversation doesn't mean that everyone all of a sudden completely trusts each other and that their concerns are gone forever. Where it's important to sort of use the communication approach and the independent third party approach together, to get a happy base in tandem, perfect, so that you maximize the effects of both. It's not a sort of one of them is a plug-in solution and just choose. They have to sort of be wielded with each other in mind.
I completely agree with that. But I do think that the independent fiduciary can quell any potentially issues that come up, because when we see litigation happen, it's usually because emotions have taken over. So I find that, and again, I agree with you completely that a communication plus independent fiduciary plus what I call bifurcation of interest between the surviving spouse and the children is the recipe for success. But just having someone who's not emotionally vested sometimes can ward off the tensions that arise.
Mm-hmm. Yeah, I mean, it's sort of the same thinking behind bringing in a moderator for ADR or something like that. It's a little different, but it's the idea that there is, we can't trust talking to each other, so we have someone else who's sort of,
right,
in this case moderating, but also sort of acting as like, I know the word of God because I know that I represent the deceased patriarch, so to speak. So, I'm the personal representative of the person who's not here. And so.
Right. Exactly.
You mentioned a great word, or the bifurcation of the interest of the spouse and their surviving children. Let's, I think, explore, how that can happen in a better way than just sort of leaving, as we mentioned before, the spouse gets it, and then after her death or his death, the children all equally inherit, where you sort of create inadvertently that conflict that we spoke about earlier. What are some ways to do that better?
Yeah, I think that trying to determine what do you want the end game to be when you're planning? You want the surviving spouse to have access to, all of the residential homes, for example. Okay, well, maybe instead of putting them in trust for the surviving spouse, maybe we look at giving spouse an outright interest in certain properties, or maybe we let the spouse direct where certain assets are going to go. And then we have other assets that are specifically for the benefit of the children from a prior marriage. Sometimes we use life insurance to fund that type of arrangement. So we're going to make sure that in the big scheme of things, we're treating everybody equally, but we're going to use different assets to benefit different interest holders, if you will. So in the Ozzy Osbourne example, Sharon and their kids, for the most part, probably have a common interest. It's the kids from the prior marriage that may not have the common interest. And so just being able to bifurcate, which is where I came up with that, those interests, so that they're not stuck together, the kids from the prior marriage and the kids from the marriage with Sharon, can be really helpful to mitigate fighting going forward. So we might say there's life insurance for the benefit of the kids from the prior marriage. There's going to be certain assets that are held for their benefit, and then certain assets that are held for Sharon and the benefit of the kids of the common marriage.
And you're also, you're sort of diversifying the plan, right, a little bit to make these assets, to make the desired result happen. Whereas you don't have to leave, just because assets in the estate start, in one form, that doesn't mean that they have to be passed on in exactly that form. So you can get creative with how exactly, what form those things are going when the transfer is occurring, because that's ultimately what we're talking about. Always, you have to remind people that, we get caught up, especially with the political discourse surrounding it about, death taxes and things. But, a death in this case, we're talking really about transfers rather than the implications of death. So, when these transfers happen, that's what the estate planning attorneys think of, how to make these transfers happen as seamlessly as possible, and then the implications of those transfers.
Right. And also really analyzing the types of assets, and this is probably a good segue into the royalties discussion. But being open and honest about what's going to happen with the asset. So this happens a lot. Forget about royalties for just a second, but real property. So let's say there's 5 different homes that are owned by a decedent. Just really having a conversation about, well, is it practical that anybody's going to use one of the homes, let's say. And if it's not, then maybe selling that home and distributing the proceeds so that we don't have a bunch of owners of a piece of property. That helps mitigate conflict. Because if I take let's say a house is worth $1 million, if I take the proceeds and divide it into pots, that's a lot easier to deal with than everybody owns an interest in a piece of property.
And then just that one step, because if they want to sell it now, that they need approval from the other 4, and it becomes a whole, just to get to the same result as just selling it first, you've got, a huge amount of potential conflict.
Right, exactly. So I think that there's little things like that can be done in the planning process to really have everybody on the same page about what's going to happen with the different types of assets can be really helpful. Royalties and intellectual property are a very interesting asset class that obviously not everybody has. We see royalties and intellectual property a lot with musicians and artists and authors and those types of people. Those can be particularly challenging for a couple of reasons. Number one is they have to be valued at the death of a decedent, and sometimes that can be tricky. And then number two, deciding, who's going to benefit from those assets. So that's an asset that has a value, obviously, at death, but the collection of that asset could happen well into the future. And so kind of analyzing what that looks like and who would benefit from that is something that takes extra care in the case of decedents who own that type of property.
Yeah, absolutely. I think, obviously, especially when you're dealing with prominent artists, the tendency is for them to sort of gain fame after death, but that can be good or bad. I think, one of the more recent, I guess recent is relative now as I age myself here a bit, but, the Michael Jackson case, obviously when he died, he was less than popular, not quite at the height. The various allegations against him, and his just sort of people realizing that he's a bit of a weirdo. But sort of after his death, people were able to step away from that a bit and appreciate his music and the value of his catalog and his likeness, which before his death would have been at a low point, actually sort of really rose and is quite valuable now, quite a bit more than it was before he died.
Sure.
But that's not always going to be the case. And it's really hard to tell.
Yeah, it can go either way. And so that's the tricky part. In the case of Michael Jackson, the assets, the intellectual property appreciated significantly after his death. But it also could be that the intellectual property depreciates very quickly because people lose interest or whatever the case may be.
Fade from the public eye, yeah.
Right. Or some scandal post-death comes out and nobody cares about that person anymore. And so, deciding who is going to benefit from either that appreciation or depreciation is something to certainly take into consideration.
So, I think everyone kind of vaguely knows, royalties, like you get money in the future for stuff you did in the past, basically. But how sort of exactly does it work, if you don't mind my asking? So we understand exactly what we're talking about here. What does a royalty entitle someone to when they have a right to a royalty?
Well, in the context of Ozzy Osbourne, it's playing his music maybe that he'd written that may be in his library. That's really what we're talking about in that context. In the context of an author, it could be works that were in process. It could be the selling of books.
So it is a pretty broad and sort of case-based definition. Correct. At this point, depending on the type of artist and sort of what they're looking to do with these things.
which is why it's tricky to value those interests.
So then what can planners do? Obviously you have to give more time to this valuation. Is there anything else once you sort of address the value hurdle that can sort of, head off some of the potential pitfalls with these sort of assets?
Yeah, I think having a good understanding of what valuation looks like at various points during someone's life can be helpful. I think that it's difficult to plan with royalties. Sometimes clients can transfer royalties during lifetime. It just depends, so if it's a library of music that's already been produced, if a decedent decided, not a decedent, but someone alive decided they wanted to transfer those royalties for the benefit of someone else during their lifetime, in some cases they can do that. In other cases, it's a little bit more challenging. So it is possible to do planning with those during lifetime, but otherwise it goes back to the same types of things that we're talking about, which is just analyzing who's going to benefit from these types of assets when I die.
Yeah. And obviously with that, because they're such valuable assets, there's the additional, concerns of someone's going to have to manage these. So it's both who deserves them and what message am I sending with that, but also who's going to take care of them in the way that makes them the most valuable for everyone.
Well, you bring up a good point, because the management of the asset post-death is extraordinarily important. If we have a library of music, let's say, the decision has to be made, is it going to be retained? And it's just going to be a cash flow asset into perpetuity or however long? Or are we going to try to monetize that asset and sell that library of music to provide for the beneficiaries in a more substantial way in terms of the actual underlying asset? So I think those are very important decisions, can really change what it looks like for a beneficiary. So again, it comes back to having someone in charge who understands A, what the decedent wanted, and B, trying to mitigate the conflict between the various parties and kind of governing with a even hand.
So, we're just running out of time here, Tasha. We've sort of tried to compress an enormous topic into about 30 minutes here, and we've been sort of all over the park. If you had to sort of, give one piece of advice for planners who are dealing with potential issues, dealing back to blended families, what would that piece of advice be, I guess?
I would say that it's talking about these issues sooner rather than later with the team of advisors. And I think the team of advisors is typically the financial advisor and the attorney and the CPA who's involved with the decedent, and having some robust conversations and fact-finding and analysis regarding how the potential for litigation can be mitigated through planning and communication.
Yeah, sort of unite the silos of information as much as possible.
Correct.
That is about all the time we have for today. I'd like to thank Tasha Dickinson for coming on and sort of helping us unpack a nebulous and exhaustive topic. Thank you so much, Tasha.
Thanks for having me, David.
And for our listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous. Every estate tells a story. Some define a legacy, while others highlight lessons learned the hard way. To avoid costly planning pitfalls, trust companies, banks, and wealth management firms rely on the full suite of modern solutions from SS&C Black Diamond Trust Services. Whether optimizing for tax efficiency, managing complex assets, or securing intergenerational wealth, Black Diamond helps you bring clarity and control to the most complicated estates. Learn more at www.sscblackdiamond.com. SS&C Black Diamond, powering the future of trust and estate management.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of InformaWealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.